Alex here with part 102 of the My Docket series on child custody and visitation. As with my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, this case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. This is going to lead into the school's resistance towards disclosing the address of a witness. The witness, the kindergarten teacher who prepared the affidavit in the case, I think she was, I don't think she quit, but I think she was on like leave, like a maternity leave or something like that. And as I've mentioned to my viewers under numerous occasions, the actual document that they prepared, that whatever witness happened to prepare as an affidavit, is only good enough, at least in Nevada, to get you to an evidentiary hearing. Once you are at the evidentiary hearing, you need to have the witness appear and testify on the stand so that they can be cross-examined. It's a due process issue. If you haven't seen my video, due process, please watch it because there are exceptions everywhere, and some states will let you just use a piece of paper. You have to pay attention to these details. Child custody cases in all 50 states can vary wildly. Anyway, in this state, Nevada, I would not have been able to do that. I would have needed to get the teacher into the courtroom. She was no longer at the school. Process server couldn't serve her at the school. Typically, you don't want to serve people at work unless the capacity in which they're going to testify is their work capacity. That's a different situation. Since she couldn't be located for service, I was going to ask the school the address to provide the process server so that the process server could then serve her at her home. This is a thing that is normal. You're allowed to find out where somebody lives if you need to serve them so that they can appear in court and provide testimony that's relevant. Please watch my video, Witnesses, because trying to get witnesses to appear against their will is risky, but sometimes you have no choice. In fact, in certain types of cases, it's not unusual at all for most of the witnesses to be compelled to appear. There have been attorneys who've said, make sure you don't get a witness on the stand unless you know what they're going to say, but that's one of the things that causes people to go into court without any witnesses at all. And I feel like in child custody cases, your own testimony as the party is taken with the teeniest, tiniest grain of salt possible. And in these types of cases, sometimes you just have to take the risk and get a witness into court that is not happy about going to court. One of the things that I want to mention is a lot of witnesses aren't happy about going to court in child custody cases because they have this weird idea. I don't want to use weird. I guess it's understandable why they have this idea. Anyway, they have this idea that they're going to court to testify on the stand about who is the better parent. They think that somebody's going to say, hey, Miss such and such, are you Army's teacher? Yes. Is dad a good dad? Is mom a good mom? Is dad a better dad than mom is a mom? And they think they're going to get these questions, and this, I imagine, is what makes them afraid to go into court, because they don't want to do that. They don't want to be the one that takes a child from one parent or the other. And what they don't understand is that the court is the one that does that. The court just needs them to state what their observations are on the issues that are before the court. So the questions that would have been posed to this teacher would have been something like, do you give Army homework assignments? Yes. On what days do you give them? On these days. On what days are they due? On which days were they turned in? On which days were they not turned in? Attendance keeper. Which days was he absent? Was he absent on this day? Was he absent on this day? Was he absent on this day? Did my ex call and give a reason for this absence? So these questions are factual. What did you hear? What did you see? What did you, it's observations. These are facts that the court needs. Court doesn't need them to say, who, in your opinion, should I give this child to? But this is, I think, the terrifying fear that a lot of these witnesses have. There was an optometrist who actually seemed to understand his role. At one point in my case, I asked him to sign an affidavit, and he signed it without question. He immediately signed the affidavit. And what did the affidavit say? Number one, when was this child's last appointment? Number two, when is this child's next appointment? Number three, has this child gone in for his appointment? That's it. Those are not who is a better parent type of question. Those are, what have you seen? What have you observed? These are safe things that the court needs people to come into court and communicate. The court then will take all of those statements that particular witness has made and then decide in the best interest of the child what's going to be done with custody. But there's this massive disconnect between the actual reality of what a judge expects from them and what these witnesses, these teachers and other witnesses like that think is going to happen. And honestly, if somebody asked me to come into court and say who is the better parent and who to give a child to, I would be afraid to do that too, because I don't know all the facts and I'm not the judge. But having gone through this child custody dispute for all these years, I know that the questions that would be asked of me would be what, my observations were. There are exceptions, guys, and that happens to be an exception that's in place for what they call expert witnesses. If you want to learn a little bit more about expert witnesses, please watch the video on that topic. Typically, those are custody evaluators, and those are like mental health providers that are in the capacity of like a therapist for the child, stuff like that. It's a little bit more blurry, but that's not what I'm talking about when it comes to teachers and stuff. And these witnesses, the dental hygienist and the teacher and anyone else who participated in my case, they help so much, and they don't even realize just little things like what my kindergarten teacher, or my son's kindergarten teacher, put together in that affidavit. Those are pure facts. Nowhere in there is she asked who's a better parent. She's just stating a series of facts. Those things help the court a lot, because if you take away all those things, all you have left is mom, dad, bickering, and who do we believe? It's very difficult for a judge to figure out who's telling the truth between two people who have a huge interest in the outcome of a custody dispute, because they're the parents of the child in the dispute. Anyway, going into what I was trying to do here is deal with the fact that the school was not going to turn over the address of this particular teacher. Ended up having to file a motion to compel, and at some point in time I ended up getting the address, and in some way I can't remember what happened at that point, so maybe further on in the My Docket series I'll have more answers for you guys on what happened following. But it wasn't too negative of an experience, because my son still goes to that school to this day, all these years later. And it didn't make me upset at the school. I didn't take it personally. I just felt that they were ignorant and didn't understand how court works. And that is not something that I can blame them for, given the fact that they're a charter school. They're not like the actual public court system, which is a humongous system with all these attorneys that can help them understand these things. Charter schools are much smaller, and I don't think they had a staff attorney at all. I don't know. Who knows? Anyway, I think at this point we can go ahead and take a look at what I have filed. Alex here with the motion to order Coral Academy of Science to show cause why they should not be held in contempt of court for failure to obey a subpoena. Ducas Tecum. By the way, guys, I have to laugh here because if you look back at the previous video, my ex's attorney is trying to sanction me for not, I guess, complying with Rule 16.21 and asking the court to reopen discovery, yet that's only on that one subpoena. Here we have another subpoena, and on this subpoena, I guess this one's okay. I guess this one I didn't have to comply with Rule 16.21 on, so just a little bit of a silly thing that I notice now at this point is that they basically pick and choose what to apply, whatever law they want to, and then other things that I'm doing apparently aren't breaking the law, even though it's the exact same thing. I don't know. Anyway, here we have the standard introductory paragraph. I'm trying to get the school ordered to show cause to explain why they aren't complying with the subpoena that I filed. Scrolling down into the, oh wait, let me see here. I identify myself as a petitioner. I indicate to the court that I'm appearing in proper person, which means I don't have an attorney. And moving into the factual background. The first assertion is that, or statement, is that on October 11th, 2012, I filed a motion to modify custody. On October 29th, I had 4 subpoenas and 3 subpoenas ducas tecums issued. One of these commanded the appearance of the kindergarten teacher. Next statement here is that based largely upon her affidavit, the court found and concluded that prima facie evidence supporting a substantial change of circumstances existed and confirmed the hearing scheduled for January 3rd, 2012. Next statement here is, in the following weeks, the school offered to personally serve her with a subpoena because even though she is on maternal leave, she occasionally visits the office. However, they apparently have been unable to make contact with her. Okay, guys, this is another thing that I did that was really nice. So I guess when I initially communicated with the school about it, they said that she was not comfortable disclosing her address. So I was like, okay, well, next time she comes in, can you give her the subpoena, or it was a subpoena, and then sign the certificate of service so I can come pick it up. Well, shenanigans occurred. Number one, well, one of two things happened. Number one, when she went in, she refused to accept it. She probably was offered the subpoena and said, no, I'm not going to take that. I'm not going to court, thinking that it was optional. Number two is that she got wind of the fact that the school was going to serve her with a subpoena, and they then instead said, then she instead said, I'm not just going to come to the school anymore. I'm just not going to come to the school anymore. I'm going to avoid you because I don't want to get that subpoena. So this is the idea that some people have, that going to court is voluntary. You know, it's not just this teacher that did this. There was also a mental health provider that did this once, and he stated that he doesn't go to court. And I'm like, well, it's nice that you don't go to court voluntarily, but certain things can be used to compel your appearance. And I understand that people don't like the idea of using force, but at the same time, we operate in a legal system that needs to make legal determinations. And for people to think it's optional to appear is actually very detrimental to the legal system, because then at that point, the next step is that you don't even have to go to court if you're a target of a lawsuit. Like, at some point, a line has to be drawn, and at some point, society has to realize that certain things need to be proven in court, and that requires your appearance. And the other thing that I want to say about that is, I think it mainly ties into all of those fears that I mentioned earlier in the video. I don't think it's that these people want to flout the American legal system. I think it's that they are afraid that they're going to be put into a situation where they have to choose who the parent of a child is. That's my suspicion. If these two people do happen to know that they're just going into court to provide observations and they still don't want to go into court, then I have a whole lot less respect for them, especially for professionals. Like, mental health providers and teachers should know better. They're a part of a larger community. They have a bigger role than just teaching. A lot of times they talk about how they're there to report child abuse and neglect to CPS. So if they're going to participate in CPS proceedings, but they're not going to participate in other types of proceedings that involve abuse and neglect, I think that's very inconsistent with what their role is in, the educational system and what we expect from them as a society. Hopefully it's just an issue of not understanding what the point of the court system is, and hopefully one day all the teachers will understand that, abuse and neglect goes way further than just CPS cases, and that they're needed to testify in all sorts of cases. In any event, I think that a lot of times attorneys are good at finding the particular providers that are okay with going to court, and they just use those providers over and over again. And I think when it comes to us non-lawyers, we don't know who they are. So we end up trying to get other people into court that just don't want to go to court. In any event, guys, I think I can move on from this paragraph. I'm going to talk a little bit more about this at the conclusion, but let's go into the next statement. I contacted the teacher to arrange for personal service at a convenient time and place, and my call was not returned. So again, guys, this isn't a case of a guy who wants to know where you live just because there are opportunities being given. Number one, you can meet the school staff. Number two, you can meet at a neutral location. I recall, now that I'm reading this, offering these opportunities, and she would not accept them. What I came to the conclusion is that she just didn't want to go to court, which is really disappointing, especially considering she put together a 4-page detail affidavit. I suppose it's possible that she may have had some sort of severe anxiety with appearing in court, but in any event, for whatever reason, she strongly resisted this, and I'm going to go ahead and scroll down. I do not imply that the school has anything but good intentions. I speculate that they would prefer to respect her privacy in allowing her to collect the subpoena. However, it has been in excess of 40 days now, and they have been unable to effect service. In the meantime, my ex has improved her conduct, and our son has not had a single absence since the 8th, and his homework is being turned in consistently. For this reason, I propose an alternative, which is addressed below. Legal analysis. So we're going into the argument now. The teacher's address is required because personal service is mandatory. This is true. Under the rules of civil procedure, you cannot just mail this to the teacher. They have to be personally served the subpoena. It's required. I'm going to go ahead and move on. Proof of service was filed by Chris Schaefer. an individual who personally served a subpoena ducis tecum. Okay, so this is me asking the school to turn over her address. The Nevada Supreme Court has specifically discussed the duties expected of a person being served a subpoena. And this is the Humana v. District Court case. I've talked about this once before, but it basically says if you have a problem with a subpoena, you need to follow the remedies available in the instructions. You don't just on your own say, nah, I don't go to court, I don't feel like it. There are 3 ways that you can challenge a subpoena, and if you don't want to go to court, you have to pick one of those 3 ways to challenge it. You have to do this. This is not optional. This is not something that you can just opt out of. In the next paragraph, we go into the Supreme Court of Nevada imposing sanctions against the hospital. Here we go into the court having discretion on whether or not it finds somebody in contempt. The applicable law and sound reason must be applied. Honestly, what I think that the court would have done in this situation if it went to court is one of 2 things would have happened. Number 1, the court would have had one of the bailiffs go and track her down and bring her into court through the use of force. Number 2, which is the more likely thing, is the court would have found a way to render her testimony irrelevant, which would have been damaging to my ex and favorable to me. So he would have tried to find a way to argue that I'm going to make this decision, therefore this teacher isn't needed in court anyway because Alex is going to win. Or maybe he would have said, I'm going to go ahead and allow the use of the affidavit that was provided by the teacher, the 4-page affidavit. I'm going to allow that to go in as evidence under an exception that the teacher just cannot be located for service. At that point in time, though, my ex's attorney could have put her foot down and said, I object, that's not fair, he can't use the piece of paper, I am going to argue for the teacher to be apprehended. And if my ex's attorney did that, it's very likely the judge would have been forced to track her down, apprehend her, and bring her to court. Once a witness is apprehended and forcibly brought to court, I think at that point in time, they're typically excused of any contempt. It really does irritate everyone involved, but sometimes that's what you have to do. There is a viewer on my channel, I think it's Viewers Victory number 5 or number 6, who actually had the former occur. She went into court, the witness would not appear in court, and the judge just ruled in her favor. He just said, hey, we don't need your witness because you won anyway. And that was one of the things that actually does happen. So yeah, if you're the other side, if you're on the other side of this coin, I wouldn't be too excited about a witness not coming into court because that kind of stuff has happened before. Petitioner must exercise due diligence to ensure the appearances of witnesses. Yeah, this is right. I have an obligation to exercise my due diligence in ensuring the appearance of witnesses. If I don't do this, if I don't try as hard as I can to get a witness into court, the court can actually blame me and punish me for that. The court can say, hey, you didn't try hard enough to get this witness into this courtroom. Since you didn't try hard enough, I don't have to go out and force her to come in. And they will absolutely do that because the courts hate having to get people like this teacher and force them to come into court. They would rather find a way to get around needing them in court. And if you try your hardest to get them into court, that can often work in your favor. But if you don't try hard enough or don't try at all to get them into court, that can almost certainly result in your losing. So just keep that in mind. There's actually case law on this that explains that you cannot complain to the Supreme Court if the judge did not force a witness to appear if you fail to subpoena the witness. In fact, I covered one of those cases for our Nevada judges. If you have a chance, guys, go ahead and take a look at the video. I think it's Bruce Gale versus Stephanie Ann Miley. And in that exact case, a witness doesn't appear and the judge uses it against the plaintiff that he failed to subpoena the witness. Going down into the alternative proposal, my objective is to ensure that my son can benefit from a wholesome education. Modification of custody was a means to that end in case my ex was unfit or unwilling. It was only because the motion to modify was filed that she adjusted her conduct. However, now that her conduct has improved, I would ask this question of the court. Even if my ex is found to have been guilty of educational neglect at the time the motion was filed, conceding that her conduct has greatly improved before the hearing, would the court still find it appropriate to strip her of custody? It's my opinion that this question will be answered in the negative. So what I am saying here is that we're at a point now where my ex has stopped all of the things that she was doing that led to the filing of the motion. And I am basically asking, hypothetically, is the court just going to basically let her off the hook And I strongly suspect at that time that yes, the court would have done that. In hindsight, I actually still agree with that. Most likely, the court would have found any reason that it possibly could have, this particular judge being the problem, to maintain the situation the way it was. And so it looks to me like I am abandoning this motion at this point in time. If the court would agree with the proposal. Okay, yeah, so it looks like there are still other issues in the motion to modify that I want resolved, but the particular modification of custody issue could possibly be dropped. And later on, it ends up being dropped. I mentioned earlier in the series that I didn't regret doing this because I think that the judge would have found a way to deny the motion anyway. Now that I'm here looking back, it's possible that I could have made an appeal out of the issue, but I still think more likely than not, I would not have been able to successfully achieve the modification of custody with this judge. I think with a different judge, I could have won, but with this judge, I think he would have. He was looking for too many reasons to rule against me. The self-representation bias was at an all-time high in this case, and I don't think that I could have overcome that given the fact that my ex had stopped doing all of the things that she was doing prior. It also doesn't help that the legislature hasn't put into effect any sort of statute that deals with this problem. I know that there are a lot of family law attorneys who actually want to keep discretion as wide as they possibly can. I know that it helps them win their cases as lawyers. It works against us most of the time, and it actually is where all the bias bleeds through. If you want to learn more about what I'm talking about, watch my video, Discretion. But I think all in all, at this point in time, I'm sitting here reading this, and I think that there is probably nothing that I could have changed here to change the outcome. The only thing that I really feel like I could have for sure prevented was my ex's request for sanctions, and that is going to come up more when I file my opposition, and I'm going to explain that a whole lot more. But the modification of custody, given the fact that my ex stopped doing everything that she was doing, given the fact that this judge would have probably used that to deny the motion, I think that there's probably nothing I could have changed here. The tiniest possibility of success might have come after an appeal. There would have been multiple things that would have had to have overturned that I strongly feel I would have been able to overturn on appeal. Number one, his refusal to allow discovery is egregious. Number two, his misapplication of res judicata principles is an obvious error. And then number three, this witness, I don't think he has any inclination to compel to appear. And I think that would have been an abuse of his discretion as well. So I think that in this particular situation, there would have been so many different legal errors and abuses of discretion that an order reversing is virtually guaranteed. But I think on remand, he would have eventually been forced to hold a hearing. He would have held a hearing. He would have heard the testimony of all the witnesses. And he would have said something like, well, she was doing bad things initially, but now she's doing good. And therefore, motion denied. And at that point in time, that would have been something that I could have not have appealed. That would have been an unappealable decision. So all in all, I could have really ran this thing a lot further through the process. I could have dinged him on his error rate maybe once or twice, maybe even with 2 errors. I'm not sure how the Supreme Court would deal with the legal errors that I would have brought to their attention. But in the end, custody would not have changed. And this process here still ended up helping me a lot when I filed my motion to modify child custody later on in 2014. So all of this work doesn't go to waste. All of this work ends up coming into consideration in 2014 and does have a huge impact on me winning in 2014. So I think I talk about this in a video where you can take advantage of your losses later on and turn them into a win. I forgot what the title of the video was, so hopefully I'll remember it later. And next time this sort of issue comes up, I can mention it in the video. I think we can go ahead and scroll further down. Here's my declaration, which is swearing under penalty of perjury that all the facts alleged in this document are true and correct. Here's my Rule 5 certificate of service indicating that both the school and my ex's teacher was served with this particular motion. And here we have the motion opposition notice, which according to the check marks that were marked, I do not have to pay a $25 filing fee upon filing this motion. Going into the next document, we have an ex parte motion for order shortening time. This is something that I talk about in a video. It's a pretty long title. It's something like continuances, shortening time, and enlarging time. All of that is in the title of the video. And you're going to have to take a look at that video if you want to learn how these shortening time motions work. They are supposed to be done ex parte because the timeline to respond to these needs to be shorter than the timeline to respond to the actual motion. Otherwise, it's going to become ripe for review at the same time, and that's going to be 10, 13, 14 days later, and you're not going to get that effect that you wanted, which was to shorten time. Why am I trying to shorten time? Let's take a look here. The order to show cause I seek to shorten time on is scheduled for January 3rd. I had the subpoena served on October 30th. Okay, yeah, the problem here is that I gave the school all this time to try and figure out how to get the teacher the subpoena, and all this time went by and they failed to do so. Here's a local rule, WDCR 11 subsection 3, which talks about how you can get an order shortening time by an ex parte filing. It's a local rule. Here's another local rule that I think requires some kind of special notice. Oh no, it's just one of the ways to serve under Rule 5, which is personal or by mail. And then here's just my argument saying I need this to be resolved very quickly, because if you don't resolve it very quickly, we're going to have to postpone the hearing. Here's my conclusion, which indicates that if this motion is denied, then the order to show cause motion would be moot, because by the time it would be due for my ex to respond, we're going to miss the hearing. The other thing the court could do instead is order a continuance, but I think the court just doesn't want to even deal with it in this case. Another declaration in under penalty of perjury, swearing that all the facts alleged here are true and correct. And then we have Rule 5 Certificate of Service indicating that this ex parte motion for order shortening time was personally served upon both the school and my ex's attorney. Here we have the request for submission indicating that the shortening time ex parte motion is being submitted to the court for decision right now. That's the only thing, though. If you notice, it's only the ex parte motion for order shortening time. The other motion, which is the one that's trying to hold the school in contempt of court, that one is actually going to continue on the normal track, at least until this order is granted, which I hate to break it to you guys. Spoiler alert, it's not. A certificate of Rule 5 service, and here we have another certificate indicating that I personally served the attorney, my ex's attorney, and the school with this request for submission. Going into the aftermath, I filed 1, 2, 3 documents, but they were all free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney would have probably spent no time at all on the request for submission, maybe 5 minutes max on the ex parte motion, and I suspect 10 minutes max on the motion for order to show cause. The reason why is it wasn't served on her. I mean, like, it was served on her, but it wasn't targeting her. She wasn't required to do anything. Her client wasn't required to do anything. It was the school that was, on the hot seat. So I'm sure that the attorney just reviewed it, glanced over it, 10 minutes max, put it into a computer system, and that's it. Total of 15 minutes for all 3 documents at the rate of $250 an hour. It's going to come to $62.50 for my ex in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.